Welcome everyone to our topic today, Demystifying Probate. We are going to go through a bunch of different areas today, and I will see what we'll do is after each main topic, I'll pause and see if there's any questions. As Michelle said, you can type them right into the Q&A section on the site, and we'd be happy to answer. So let's get started. So demystifying probate. What is probate? I mean, one of the main things that happens consistently when somebody comes into our office, either after a loved one has passed or more likely even when they're planning out their own estate plan while they're still living, I say to them, well, let's talk about probate. And their response is, I don't need probate, I have a will. It's kind of across the board what I get. And it's very important for people to realize that probate can't happen without a will, and a will can't be administered and followed without probate. They require each other. It's a really base concept, but it's really important to understand as we launch into all of this. So probate is actually the process of taking a last will and testament after someone has died, bringing it to the court with a petition for it to be admitted to probate is the terminology we use, so that the executor can be officially appointed and so that the wishes can be followed, the assets can be collected, and the wishes as listed in the will can be followed. So you may have had a situation where a loved one passed away and they had a bank account, and you went to the bank and maybe you had an original death certificate with you, and maybe you even had the original will with you, and you said, I'm here and here are my documents and I'd like to collect that bank account. And the bank says to you, you need letters testamentary. Or a letter from, so then we eventually get a call, right? And it's, so-and-so called and they said they need a letter from the lawyer or a letter from the court saying that they're executor, or a letter from the court saying that they are the beneficiary. What they're actually saying to you is you need to go through the process of probate, and the completion of that process results in a certificate being issued to the executor that is appointed. And that certificate is referred to as a letters testamentary. And that means your last will and testament has passed the probate process, and now the executor has been appointed. Until that process is complete, the executor doesn't have any powers. The executor may not end up being appointed. The document as written is a list of the testator, the person who signed the will, the person who's deceased. It's a list of that person's wishes. This is who I nominate to be executor. This is who I nominate to be successor executor. And this is my wish as to how my assets are distributed. But we need that probate process because we need to prove that that will is a valid document and that that executor will be appointed by the court, that nobody's contesting it for any reason. And so that's what probate is. So remember, probate needs a will needs probate. Now, let's go into what about if you have a bank account with a joint owner? You have a joint bank account holder, or you have a beneficiary named on an account, or you own a property joint with rights of survivorship with someone. In all of those instances, it doesn't matter what the will says, and you don't need the probate process because that asset will be distributed to the joint owner, to the beneficiary without that court process. So let me give you an example. Say I die and I have a checking account with $50,000 in just my name. Let's say $60,000, just my name. I have an IRA with the beneficiary, and I have a co-op in just my name. Well, immediately after I die, if my death certificate is presented to the bank that's holding my IRA, that bank is going to contact the beneficiaries I have listed on file with that IRA, and they're going to give those beneficiaries the directions for how to get that money. That doesn't require probate at all. However, in addition to that, the executor that I've named in my will is going to have to bring my will for probate with the court, because that co-op is in my name and that bank account is in my name. And so there will have to be a petition for probate, and the process will follow. And I'm going to go through the process in a minute, but I want to make sure that everybody's very clear on when you even need probate. Now, take those same 3 assets, but say my bank account had my spouse joint on it with me. And let's say my co-op that I lived in was joint with my daughter. Well, now I have a bank account that has a joint owner. I have a co-op that had a joint owner with rights of survivorship. And I have a retirement account with a beneficiary designated on it. If those are all of my assets, then my will never gets probated. Now, my spouse is getting my bank account, my daughter is getting my co-op, and my beneficiary and my IRA, whoever it is getting that. Now, what if my last will and testament said that everything goes to my favorite charity? Well, the charity loses out, because since there were no assets in my sole name without a beneficiary, my will never gets probated, and my charity that I've named in my will never gets anything. There was nothing there for them to get because there was nothing to pass through probate. So I'm going to just pause for a minute and see if there's any questions on that base topic of probate, what probate is, and when we need probate. There's a question about power of appointment. So the way I'll answer this question is, there's a question here about a small estate. This is why I changed my bank account amount to $60,000. If you have less than $50,000 in probate assets, then there can be a shortened proceeding called a small estate proceeding. In New York, it has to be less than $50,000. So if there are less than $50,000 that pass through your will, then that will go through the small estate rather than through a full probate. The big difference, other than it's a shorter process, is that it's only a $1 filing fee for the small estate. And for this individual who has a little bit of a more complicated question, I'm going to say if you could email us at info@burnerlaw.com on this specific topic, then we can address it that way. That would be better. So the next topic that I'll go into is, what is that probate process? And you may have heard people talk about, oh, you have to avoid probate. Probate's terrible. What's so terrible about it? Well, let's get into that. So when you sign a petition for probate, so in my example, I've died, I signed a will, and let's say Michelle is the executor that I've nominated to act in my will. Well, then upon my death, very simply, Michelle will take my death certificate, she'll take my original last will and testament, and she will probably go see a lawyer, and she'll let the lawyer know what has to be done. And there will be a petition created for probate that Michelle will sign as the nominated executor, asking the court to admit the will to probate and to appoint her as the executor to issue those letters testamentary. And I will have, Michelle and the lawyer will have to give notification to all of my legal next of kin. And when you hit a level of next of kin, you don't have to go further. So what do I mean by that? Now, anytime I sit down with somebody to do their will, one of the first questions I'm asking is about their family tree. I want to know who the next of kin are, how many there are, do we know who they are, do we know where they are? So if you are married and you have children, those are your next of kin that require the notice and require involvement in your probate, spouse and children. If you don't have a spouse or children, then it's your parents. If your parents are deceased, then it is the other children of your parents, your brothers and sisters. They can be half as well as full. It requires any blood relation, but a half is treated the same as a full sibling. Then for any predeceased sibling, it would be that sibling's child or children, etc. If I don't have siblings and I never had siblings and therefore they don't have children, and then I get to first cousins, well, then the first cousins are the ones that have to be notified. But I want to point out that if I found somebody at these other levels before I've hit that, my spouse, my children, my parents, my siblings' children, then I never get to the next level, to the cousin level. You stop where you find someone. So when we're looking at what probate is going to look like, it might look different for everybody who is on this call today. Why? Because some of you have spouses and children, some of you don't. And if anybody has heard me speak before, you've heard me talk about one of the best examples I can show of why somebody would want to avoid probate if they're not aware of their next of kin. So two individuals came to us after their friend died. We didn't know him while he was alive. And they came to us and they said, our friend died. We're the co-executors of his will. We are 50-50 co-beneficiaries. We want to go through probate. We need to get the money out of the estate. So we said, okay, well, we are going to do the probate petition. Now we need to know about the next of kin. Well, he was unmarried, no children. He was in his 90s, so his parents were deceased. He was an only child, so no siblings. One parent had been from Paris, the other was from Egypt. They met over there and came here. It was very unclear, and over there, I mean the other side of the world. It was very unclear if the parents had siblings, and if they did, they would have been deceased. If they would have had children, which would have been the first cousins. And so they said, well, he doesn't have any next of kin. And I had to tell them, everybody has next of kin. You just might not know who they are. So in that situation, in order to complete the probate process and in order to satisfy the court that we notified the next of kin, we had to hire a genealogist who was set to do a genealogy search, to do a family tree, and to basically determine if they could determine who the next of kin were, to do that. And if they couldn't, to show that due diligence had been done and that they tried their hardest to find the next of kin. And then at that point, we ask the court to do what we call substituted service, meaning if you've ever looked in the newspaper and you see they're about this big, those little death notices in the back of the newspaper saying so-and-so died, and if you have any questions about the estate, come to court on this day. That's because that individual's estate is being administered. Either they have a will and it's going through probate, or there's just an administration. And they're saying the court has made the executor or the lawyer involved put that notice into a newspaper where they're likely to believe there might be family members, so that those family members could have the opportunity to come forward and represent the estate or contest if they wanted to. So probate can be very difficult if you don't know who your next of kin are, or I should say, if you're disinheriting those next of kin. So you might have a very simple family tree, right? Spouse, 2 children, no problem for who to notify for probate. But what if you're not giving anything to one of your children? What if you're giving everything to the other child? Well, that child that you have to give notice to is going to get a copy of that, is going to see that, and can come in and contest. And they are invited to come in and contest. They're sent, if they don't sign a waiver saying that's okay, I'm not contesting here, then they get a citation in the mail that basically says, you know, your mom's will is being is going through a court process on this date. Come to court and tell us why you think this will shouldn't be admitted to probate. And so we're inviting that individual that's being cut out to come in and say something about it. And so if you are willfully and doing it on purpose, you might not want that to happen. The reason that happens is because if it is subject to undue influence, if a will was put under your nose on your deathbed and you had no clue what you were signing, then the court and the system really wants there to be an ability for your family member to come in and say, hold on, this doesn't make any sense. Why is everything going to this person? So when we talk about avoiding probate, we're often avoiding it because we don't know who the next of kin are. We might know who they are, but we're disinheriting one or more of them. If you have a disabled beneficiary, you may want to avoid probate because that could require the court to appoint somebody to represent the interests of the disabled person, which could be more of a drain on the estate monetarily and take more time. If you own property in multiple states, so if I'm a New York resident and I die in New York State, but I own a condo in Florida or a cabin in Vermont, well, if I own it in my sole name with no beneficiary, then there has to be a probate in New York because that's where I live. And then what we call an ancillary probate in the other state where I own property. And so if you own real property, you own dirt, you own a residence or other home or vacant land in another state, well, then you're going to want to make sure that you avoid probate to avoid those multiple proceedings. So the other reason that I've really been pushing people to avoid probate recently is administration time, and time means money when you're talking about the costs of administration. So I can give you an example of a client who died inside of their co-op. They never took the steps to put the co-op apartment into a trust. And so upon death, they died in the apartment. The police sealed the apartment, and the apartment building, the management of the co-op agreed that nobody should be allowed into the building. And nobody could go into that apartment until the will was probated. That meant food was sitting in the refrigerator. It meant nothing could be cleaned out to get the apartment ready for sale. It meant that month after month, somebody had to be paying those maintenance fees for the co-op, and all the other things that go along with this type of delay, not to mention the beneficiaries waiting for their share. It wasn't until probate was completed and the executor was officially appointed that there was anyone with legal authority to go in and start to do those things. Now, the problem can become that is just an added up expense over and over. And depending on the county, probate can take a really long time. Right now in New York County, it's not uncommon for us to see 6, 8, 10, 12 months for a probate to go through. And even more in some other counties. Kings County is on the slower side. And obviously this has to do with the bulk of and the amount of deaths based on COVID, as well as prior to that, you know, when you have these populous areas, it's very hard. I was giving a CLE at the Bar Association, and I was listening to the person speaking before me, and she was from a county upstate New York that's not very populous. And she said that when they apply for letters for probate of a will, she can get them in 3 days. And if she's really nice, she can get them the same day. The rest of the room laughed because that doesn't happen down here. We're just too populous of counties for the county surrogates court to do that quickly. And so that delay is a really big deal. And so we've been really talking to clients about not just what are your wishes for how your assets are distributed after your death, but how important is it to you that it be done in an efficient and fast manner? Because if that's important to you, then we're starting to go beyond talking about probate. We're starting to go beyond talking about wills, and we're starting to get into talking about trusts and other ways that we can avoid probate. And I'm going to touch on that a little bit today.
Britt, before you touch on that, I don't think
Sure.
you touched on this, but there was a question about what about children who are outside of the marriage? You spoke about the simplified families, but we were asked that question.
Yeah, great question. So it has to do with blood relations. So if upon my death, I have a spouse and a child that I had with my spouse and a child from a prior marriage, or not, maybe not a marriage, but a child from a prior relationship or a post relationship, that child is my blood, and that child would count just as the one that was of my marriage. So it's the same thing. If that child is mine, it counts. Same with if you are, a child of a parent, and they come in and they say, my mom died, but I have a half sister here and a full sister here and a stepsister here. Well, your half and your full counted, but that stepsister who is not a blood relation to your parent, therefore isn't a blood relation or isn't involved in this process. I see there's also a question here about co-op boards not allowing the transfer of shares to a trust, and asking about that. And that's a really good question. So it used to be that the answer was no, you can't ever do it. More and more, I'm finding that co-op boards and the attorneys advising them are understanding that there's ways for the co-op to allow this flexibility to their the people who live in the building without harming the co-op or making it so the co-op loses anything. So we are finding that co-ops are allowing transfer to trusts more and more. There just might be certain protections that they want built into the trust. And so I would say if you live in a co-op who is resistant, that is resistant to allowing, and just so people who don't know about co-ops understand, in a co-op, it's you own shares of a corporation. So if you want to transfer the shares that you own so that your trust, for example, owns those shares, well, then in that circumstance, you need this corporation to issue new stock certificate, new shares to your trust, to the new owner. And so we need the co-op, in that circumstance, as opposed to if you own a private home or a condo, all we have to do is prepare a new deed and file it, and there's no issue. So the co-op, it's hard, we need them. The other party that we need in a co-op is if there's a mortgage on the property, we actually need the bank involved as well, because they're usually holding on to the original stock and lease for the co-op. My best argument to a co-op that is resistant to allowing this type of transfer would be the delays of probate. We have a case recently where it has taken over a year for various reasons for the executor to have official letters and be appointed. And not only do they not have access to the apartment, but they don't have access to the money in the estate either. And therefore, no one has paid the co-op maintenance in all of that time. And if you have a $2,000 co-op maintenance and it's not being paid for 12 months, that racks up pretty high. And a lot of co-ops wait, and when it's sold, they get paid back, or once the money is gained from the estate, they get paid back. But we have one right now that doesn't want to wait, and they're saying that they're going to take legal action, and that costs the co-op money as well. So I would say that if this property could have been more efficiently dealt with at the death of the individual, of the co-op owner, well, then they wouldn't have been waiting all this time for that money. And so I think it needs to just be continually reiterated to the attorneys that represent co-ops and to the boards themselves that it really could be a protection for the co-op to allow this to be done, expeditiously at the time of an individual's death. Also, obviously if food is in the apartment and other things like that, to me, there's a large concern about vermin and other issues in the apartment that can spread to the rest of the building. So you really want to make sure it's being properly dealt with. I think those are all the questions on that topic. So that's really the process of probate and why we avoid it. So if we do going back to the basics, we file that petition. We either get all of the people required to get notice to sign what we call a renunciation or a waiver and renunciation, saying that they're okay with the will being admitted to probate and with the executor being named as executor. Then it moves forward so that the decree, the court order, can be issued and the letters testamentary can be issued to the executor. Then once the letters are issued to the executor, that is the official document that the executor can bring around with them to the different banks and institutions, et cetera, that gives them the power and the authority to collect the assets and distribute them according to the terms of the will document. And there are certain, once that executor is appointed, they are what's called a fiduciary. So they have a heightened sense of responsibility to the estate. So you have to make sure that if you're the executor, you understand what your responsibilities are. All too many times we get people who come in a year after they've been appointed as executor, and they're at a point where the beneficiaries of the estate are bringing legal action because the executor hasn't done anything. And the beneficiaries want to make sure there isn't waste on the estate, waste on their assets, and that the assets are distributed to them properly. So as executor, it's important to understand what your role is, understand what your responsibilities are, and to make sure that you're acting those responsibilities out. A lot of people say, well, what about the power of attorney? Can't the power of attorney pay the bills and do all those things? No, a power of attorney dies with you. So at the moment of your death, the agent you've named under your power of attorney ceases to act. They do not have any authority after your death. That's really important. It's very commonly confused, and they think the power of attorney can continue handling things, but that is not the case. The power of attorney is gone once you are. Just practically speaking, when you have an executor, the court isn't going to appoint someone who doesn't have and the banks won't allow them to open a bank account if they don't have a social security number. So we're always recommending that people have US citizens or at least permanent residents be named as the executor on their document. With the US green card, generally they want a New York State resident to serve jointly with that person. For anyone, I don't practice law in Florida, and I should have said at the beginning, this is all meant to be educational, not legal advice. And I'm certainly not meaning to give legal advice in Florida, but in Florida, they actually require that you be a resident of Florida to be appointed executor by the court. So if you are, if you die a domiciliary of or a resident of another state, it's going to be that state. The laws might be different, and that's an example of one where it is. So what I had said before was all the reasons why we want to avoid probate, the delay and the cost being a big part of it, but those other factors as well. And so how do we do that? And the way we do that is by creating a trust. If your only goal is to avoid probate, then you can create a revocable trust. It's yours for your lifetime. You put your assets into it. You actually title your assets into the name of the trust. So say with the co-op, you would make the shares of the co-op be in the name of the trust. And remember, probate is when assets are in your sole name with no beneficiary. Well, if the co-op or the bank account is in the name of your trust, it's not in your sole name. Therefore, it avoids probate. And that's, again, an important distinction to know. On some estates, the court requires a bond be set. This is basically security on the estate in case something goes wrong. And so you would go through a surety company who would basically pay a premium annually out of the estate in order to insure the estate. That's not required in all cases. And a lot of times the last will and testament will actually waive that requirement, especially if it's a family member that is serving as the fiduciary, as the executor.
And Britt, we have a good question on that. Speaking of that, who decides how much the executor should be paid for all the work that they do to distribute the assets of the estate?
So generally speaking, a last will and testament will provide for compensation. And most of the time, the compensation will read that it is statutory compensation. That's all that the will actually says itself. What that means is that the estate, the Surrogates Court Procedure Act, we call it SCAPA, but it's the laws that surround wills and trusts and the surrogates court, has a formula set up for what executors receive. I am not going to pretend to remember because I have to look it up every time, but it's something along the lines of $10.50 for every $1,000 up to the first 400,000, and then it's diminishing after that. So basically, you could have an estate that requires a lot of work, that doesn't have a lot of value monetarily, and therefore the executor may seem to be grossly underpaid for what they're doing. I have had clients who've said, you know what, I know that whatever that executor's commission is going to be isn't going to be enough. They have to find a home for my 5 pets. They have to clean out my apartment and I'm a mess. They have to deal with my family members and they're mean, and no amount of statutory commissions is going to be enough money. And therefore, I've had clients who've said something along the lines of, if so-and-so serves as my executor, then they can receive, and it gives a set amount of money. And so there are circumstances where people give an additional amount of money to family members serving as executor. But someone can also waive compensation. So either the executor can refuse to take it, or the creator of the will can say that they are not, they don't plan on compensating their executor. But you know, the executor always has the opportunity to say, well, then I'm not serving as executor. So it depends how the document's written. But for the most part, it is a statute that will determine it. And most executors will tell you that they're not doing it for the fee, because it's not a great sum of money. And I think, is there another one, Michelle?
There is another question. Actually, we have a couple coming in, so I'll just take these one at a time.
Okay.
Is the total value IRA, joint bank accounts, and CDs included in the small estates limit?
In the small estates limit, it includes everything that is one of those probate assets that I referred to. So no beneficiary, no joint owner. So in your question, if you have a joint bank account, no, that's not included because it doesn't have to pass through probate. If you have an IRA and there's a beneficiary, no, it's not included. But if those don't have a joint owner or don't have a beneficiary, then yes, it is included in the probate estate and would go presumably over the $50,000 limit. Also, when you do a small estate, the issue is you're given letters for a specific item. So you might be given letters that say to collect the Chase bank account number, and it has the bank account number. So a lot of times we don't recommend people do a small estate unless they're really certain that it's going to be less than 50,000, because let's say, you know, there's a bank account that's 40,000. So that's what you think you're looking at, right? And so you say, okay, we're gonna do a small estate, just a $40,000 bank account. But then an income tax refund comes in of $8,000. Now we're at 48,000. We're getting kind of close. Then there's another asset that's found that we didn't even know existed. There's an old life insurance policy, $2,500, and it has no beneficiary named. Now we're over 50,000, we have to go into a full probate. And so we wasted the time doing that small estate proceeding when it would have made more sense to just do the full probate. So a lot of times, if someone's not sure of exactly what the assets are going to be, or if we're bumping up against that 50,000 number anyway, we will often recommend doing the full probate so that you don't have to go back to the court later, because it just, the difference in the filing fee isn't usually worth it.
So Britt, the second question I think that goes along with this well is the executor's duty only to act on behalf of the will, or can they be gifted as well?
I'm assuming that that person's asking if the executor can be a beneficiary, and the executor can, and often is, a beneficiary. If your spouse might leave everything to you in their will and have you named as the executor. Same with if there's children, or those children are often the same. They're the executor as well as a beneficiary. Yeah.
So I think the next two questions are great segues for the next part of the seminar. So I'll read you, Britt, these two questions, but I believe they're asking pretty similar, the same question.
Okay.
What is the best method to leave my house to my 3 children without going into probate and avoid the house being subject to legal action if one of the children runs into legal problems requiring financial payment? So that's the first part. And then another attendee with a similar question. In your opinion, what are the best ways to avoid probate on the home, assuming the home is individually owned at death?
Great. Okay. Those do go very well together. So generally speaking, I'll tell you my favorite way to give away a home and avoid probate is to do so through a living trust. There is something called a life estate where I sign a deed reserving a life estate in myself, giving the property to someone else, maybe it's my children, and they are what are called the remaindermen. And as I get older, according to the IRS charts, my percentage of the house decreases. And then immediately upon my death, my remaindermen own it. But I don't think that accomplishes, or it does not accomplish, the first person's question about creditor protection for the children. It also doesn't accomplish protection for me if I go into, say, a nursing home and I need to sell the property while I'm alive. It doesn't fully protect the home. And so I don't believe that the life estate really accomplishes the goals as well as a trust does. But I do want to mention it because it is something that's out there. There are many types of trusts. Let's just talk first about a straight revocable trust. A revocable trust is a trust that's just what it sounds like. I create it. I'm the trustee. I can revoke it. I can amend it. I can do anything I want. I can take the assets in, out, sell them, whatever I want, gift them while I'm alive. It has my social security number. It doesn't even have a separate tax ID number. And to the earlier question about co-ops, very often when co-ops don't allow irrevocable trusts, they at least allow revocable. So while it might not be 100% the best, it can get us part of the way to our goal. The good thing about the revocable trusts, and this will apply for most of the trusts that we do with somebody's residence, is it takes it out of my name, so it's out of probate. Because remember, I don't own it in my sole name, so it doesn't go through probate. So it's not subject to the court. We're not waiting to sell it. We're not waiting to transfer it. And my will can say that when I die, I can that my will distribute to this person's question to my 2 children, and I can give it to them in what's called, or what I call, a descendants trust. So I can give my home to them in a trust where, if dealt with, if drafted properly, and if followed properly, can give my child creditor protection if they have issues with their own creditors, divorcing spouses, estate taxes if they're incredibly wealthy. And so passing a property through a trust can make it so it's my property for my lifetime. So I'm dealing with the taxes, the real estate taxes. I might have a property tax exemption for being a veteran, for being a senior citizen. All that remains. Upon my death, it's just like it was mine for tax purposes. So I get a step up for capital gains, meaning that when I die, if my kids sell it for right around what it's worth when I die, then there is not going to be any capital gains tax, which is the type of income tax on the sale of the property. That's a huge benefit that we maintain in the trust, as opposed to me just giving it away. And I can pass it to them with that creditor protection. So that is the simplest. Revocable trusts are we want to avoid probate. How do we do it? That's how we do it. Now, I know there's a follow-up question here. What about Medicaid? Now, the Medicaid is different. Now, if I need to go into a nursing facility and I don't want my home to be touched by Medicaid, or I don't want more importantly, I don't want my Medicaid to be denied because my home puts me over my resource level. Well, in that case, I would put my home, in the perfect world, I'd put it into an irrevocable Medicaid asset protection trust. And then after 5 years, it has to be in there for 5 years. Then at that point, the trust would have a protective layer around my home if I needed to go into a nursing home, meaning that that property in that trust would not count as mine when applying for Medicaid. I tell Medicaid about it. It's not a secret. It's not, everything's on the up and up, but they can't touch it legally because it's been in that trust for 5 years. And then when I die, they can't recover against it because Medicaid can only recover from my probate estate. Now, I want to make a distinction here between home care and nursing home care because there is a big difference. What I just told you with the 5 years and it not being being protected has to do with a nursing facility, but many of our clients are actually applying for community Medicaid or home care Medicaid. In that instance, the community, actually, we had a consultation today about this. I have someone who applied for community Medicaid and they own their home, but that's okay because it's underneath the $900,000 equity limit. They're allowed to own a home and receive home care services from Medicaid in that home. The home is exempt for eligibility. But if that individual dies and that home is in their sole name and has to go through probate, Medicaid can put a lien on it. So very often, especially if I have co-ops that won't allow the irrevocable, or if I have clients who are very certainly not going to a nursing home, or so they say, or if they don't feel comfortable with the irrevocable trust, if we put the home in a revocable trust, we've at least protected it so that they will not only get home care eligibility, but they will also not have that probate estate with the house in it after death where Medicaid can recover. So again, I said once, this is educational. This is not meant to be legal advice because as you can see, there's a lot of nuances to this. You say, well, I own a home. What do I do with it? Well, is your home a house? Is it a condo? Is it a co-op, right? That's right off the bat. And then I want to put it in a trust. Well, a revocable trust and irrevocable trust. Well, why would you want to put it in one or the other? What are your goals? What's your family structure? Who do you feel comfortable naming as trustee if you can't be your own trustee? And on and on. And so there's a lot of nuance to this stuff. So you should use this information today to think about your own situation, but really seek your own personal advice as to how to handle things. I want to go backwards from trust and go back to the probate for a minute. I went through the process of becoming executor and the probate process. But what I didn't say is, what if someone does come in and contest, right? What if I am disinheriting my son and he shows up on court on the day that citation told him to, and he said, my mother would have never done this to me. And I know she didn't sign that will. Oh, and it doesn't look like her handwriting. And also, she had no mental capacity at that time. Well, at that point, this becomes a contested will and we enter into litigation. That is a turning point because one, it's going to take a lot longer now. But also then we start depositions and fact gathering, and it kind of takes over a life of its own at that point until you get to a point where either the parties settle and decide a way forward, or it might get to a point where there's a hearing and a trial, and a judge actually has to make a decision about whether or not a will is valid or not, and whether or not that executor should be appointed as the executor. And so it's a really long, drawn out thing when somebody contests. And so if that's any possibility that might happen, you really do want to look into avoiding probate. But say the executor is appointed, then at that point, the job of the executor looks very much like the job of the trustee of a trust, because you then become the person who's authorized and empowered to take control of the assets of the estate, whether it's the probate estate or the trust estate, whatever it may be, and to make sure things are cared for. And so I want to talk about that process. So, that is when we start to talk about figuring out what the debts of the estate are. So often during that time where probate is being dealt with and the executor is not appointed, some individuals, be it the executor or one of the beneficiaries, might have to lay out some money. Maybe the co-op was causing a big stink, so somebody paid the co-op maintenance for a few months. They paid Con Ed. It's a home that, we're worried about homeowners insurance. We're worried about making sure the heat stays on so the pipes don't burst. There's certain bills that may have to be paid. So you want to keep a list of those so that whomever lays that money out can be paid back off the top of the estate. You also want to be mindful of how large the estate is. Is this going to be an estate that requires an estate tax return? Because if it does, there is a time limit on doing that. And so you want to make sure that you're speaking with the accountant and you're being mindful of whether or not an estate tax return has to be filed. I'll tell you this year, and it's going to change next month in 2022, but this year in New York State, each individual can give $5.93 million away at their death without any estate tax being imposed. Some people call them death taxes, inheritance taxes. There's a legal difference between the terms, but we call it an estate tax here in New York. So if you die with $5 million in your name, and this is everything, this isn't just probate assets. This is anything with the beneficiary, anything with the joint donor, your portion of it, all of that. You add it all up, and if it's over 5.93 million, there could be an estate tax that's owed. In New York, we have something called the cliff. So think of it as a roller coaster, right? You go up very slowly up that roller coaster as it's revving up, and it's no tax, no tax, no tax. And when you hit the peak, you fall off. And when you fall off the cliff in New York, that peak is 5.93 million. And when you fall off, you're taxed back from $1. So you go from no tax to a big tax very quickly. So I have a chart here, and I'm just going to give you an example. So, at 5.93 million, there is no estate tax owed in New York State, and the federal limit's even higher. So no estate taxes at that point. If you get to the point where you have $6,150,000 in your estate, you're paying almost $460,000 in estate tax. Your estate is. So think about that. Just over the amount. And now all of a sudden you're at $460,000 of estate tax. That's a big jump. And so when somebody is bumping up against that 5.93 million, the executor or trustee wants to be aware because there might be some filings required. In New York State, it's use it or lose it. So if I die and I only had $3 million, well, then the other 2.93 million is gone. There's nothing we can do. We can't use it later. It just is what it is. There's no taxes on my estate, and we're all happy for that. However, let's say I die and I have $2 million in my name, but my spouse has $8 million. Well, if I leave everything to my spouse, now my spouse is going to have $10 million. If I don't even leave everything to my spouse, my 2 has no estate tax, and I left my 2 to whomever I decided, but my spouse still has a taxable estate at $8 million. And on the federal side, the current exemption is actually 11.7 million, and it's going up next year in January, next month, to 12.06 million per person. But we can use our spouse's exemption, and I'm going to explain how. So again, New York State, it's use it or lose it, 5.93 million each. Federally, you'll have 12.06 next year each. And if you 12.06 million. And I should say that in 2026, that number is going to go back down to 5 million index for inflation. So probably around 6 million. So if you plan on living beyond 2025, keep in mind that that number is going to go much lower than it currently is. But let's take my same example. I have 2 million, and given the numbers I just told you, let's say my spouse has 11 million. So that means that when I died, there's no tax. It's just $2 million. But when my spouse dies, if I left them my 2 million, now they've got their 11, my 2, my spouse has 13, my spouse has a taxable estate. But on the federal side, if my spouse had filed an estate tax return when I died, then my spouse can use the rest of my unused exemption. So what does that mean numbers wise, right? So if I died this year, 2021, I had an $11.7 million exemption. I only used 2 of it. My spouse can, if they file timely and correctly, gets my other 9.7 million when they die. So if now my spouse dies after 2025, in 2026 or later, and the exemption is 6 million, and my spouse now has 15 million because it's grown, well, then think about that. That's 9 million over. But good news, my spouse has my 9.7 left. And now my spouse has no federal estate tax. And again, this is relevant whether we're talking about wills going through probate or trusts that don't go through probate and it's a private proceeding. So as the executor, especially if you're worried about the timeline of things, you have to be very conscious of whether or not estate taxes have to be paid, or if that tax return has to be filed for the spouse who had a lot less money to save the other spouse later. And there is a strict timeline on that, 9 months from date of death. And so you want to make sure that if you're the executor, you're the fiduciary, you're in charge of that estate, that you're watching what is happening with the estate taxes.
Britt, I think maybe the order that you want to answer these, so I'm just going to skip around really quickly.
Okay.
So because you were just talking about the estate tax, does the surviving spouse get the entire 11.7 million because of the unlimited marital deduction?
So it depends. That's a good question. I was mixing my examples so I could see how that was confusing. It depends who I gave my 2 million to. So if my spouse got my 2 million, then yes, I didn't use any of my exemption. So my spouse would get my full 11.7. But say I gave my 2 million to my, daughter from a prior marriage and not to my spouse because my spouse didn't need it. Well, then I used 2 of mine. So my spouse only gets the balance.
Okay, and then we had just another question. Somebody just missed the portion about the descendants trust. If you could just repeat the fact of how the creditor protection falls when you leave it to a descendants trust.
Sure. So when you leave assets behind in a trust, in a descendants trust, as we call it, and that's just our terminology for it. When you do that, you actually are, you can create creditor protection for your child. So if you leave your house, if you have a revocable or an irrevocable trust and you name your son as beneficiary of that trust, but he is to get his share in a descendants trust, he can, in most cases, be his own trustee and manage it himself. But because of the way the trust is written and the restrictions that are put on him, he can receive creditor protection. So if he has creditors, divorcing spouses, a taxable estate himself, he can be saved from that on the assets that you've left behind in the trust. And I want to point out that a descendants trust it can be made in a trust, and that's how we prefer it to be done. But you can actually have a will that goes through probate that says, when I die, everything goes to my son in a trust. And that descendants trust is actually created through the probate process. The problem there is that any time that you have wills that are going to create trusts that are going to extend beyond your lifetime, We don't like to do that because then the trust will always be under the surrogate's court because it was created by the will in the surrogate's court. So fast forward, and now your son is older and your son can't be his own trustee, and a successor, maybe his son has to be his trustee. They have to go back to the surrogate's court and ask the surrogate's court to appoint the successor trustee. Whereas if it's all done through a revocable or an irrevocable trust that you've made during your lifetime, it avoids any of that court intervention. So that's yet another reason why we like to avoid probate. And that's when there are these ongoing trusts. I think I've covered the main topics. The last thing I'm going to say, and then I'm happy to stay and answer questions for as long as people have them. So please feel free to keep putting them in the chat. Is once you have collected all of the assets and you've paid all of the debts, again, being the executor or the trustee, and you're now at the point where you're going to start distributing assets to the beneficiaries, at that point, you don't want to distribute any assets out to a beneficiary without getting them to sign a receipt and release. A receipt and release is a document where they say, we got an accounting from you as the fiduciary. Now that might be an informal Excel spreadsheet accounting. If there's one bank account, it might just be statements showing the in and out of the account. Every situation is going to be different of what kind of accounting is necessary. But as the executor, as the fiduciary, the trustee, you don't want to distribute assets to the beneficiaries until they've signed off, because you don't want them coming back later once all the money is gone and you don't have the money in the estate to protect yourself or to defend yourself anymore. And they might say, wait, you paid too much money for this, or we don't agree with that, or I think you stole this. You don't want to, you want to allow yourself to be released from liability once you've completed your job, because otherwise you could be on the hook forever. And who would take that job, right? Nobody, because you don't want to be on the hook ongoing. So if a beneficiary is to receive a distribution, they're going to sign off a receipt and release beforehand to protect the fiduciary from liability going forward. And that has to be a knowing receipt and release. So it's not just enough to sign a document and say, sign on page 4. The document should actually say you've received an accounting, you reviewed the accounting, you've had an opportunity to ask questions, and you are now knowingly signing this waiver of any future liability. And that's what really makes that important. So that is crucial. There's some cases where a trust or an estate that goes through probate has cash assets and property, and you might do a partial distribution of some of the cash assets and just leave some cash to keep the property going, and then do another distribution after the property is sold. And that's okay. And every situation, again, is going to be different based on what the assets are and sometimes what the dynamics are between the individuals involved in the estate. Okay, Michelle, what do we have next?
We have another question. So you guys are very good. Thank you for these thorough questions and keeping us on our toes. The distribution of assets are through beneficiary on accounts, IRAs, CDs, and life insurance. So I will have control those distributions, correct? Okay, so
yeah, I think I get that question. So if you're the executor and everything has a beneficiary listed, then no. Yeah, exactly. This person just wrote in and said, I'll have no control. That's correct. You have no control. So I have someone who comes in, they say, the only thing that's going to go through probate or the only thing that's going to go through my trust is my property. I'm not putting any cash. Nothing. I said, okay, that's all well and good, but you have to realize now that if everything else goes by beneficiary designation to someone else, you're not giving your trustee or your executor any money to keep this process going until it's over. And so you might want to at least put one bank account aside that goes along with the probate property so that that property can be kept up in the right way until it's sold. So, again, who's going to pay the taxes? If it takes 1.5 years to sell the property, someone has to pay the taxes on the property. If it's a co-op, there's maintenance. If, you know, you're keeping the heat running so the pipes don't burst, all those things, you want to make sure the assets are there. So I often don't like, and if it's a taxable estate, I definitely don't think that you should have everything go by beneficiary designation, because you want to make sure that your fiduciary can pay the taxes off the top and they're not going back to the beneficiaries and, you know, begging for money to make sure the obligations are covered.
Okay, so do you think New York will ever get the transfer on death deed? I think 29 other states currently have it.
I'm not familiar with what the other states have. You know, we do have the life estate deed here, which might be a similar thing. I'm not exactly sure. And there's also that you can have an heirship deed. So for example, if I'm a single person and the property is going to vest in my beneficiaries who are my next of kin immediately at my death, there are certain cases where you can do a deed without probate, although title companies are often very suspicious of that, and it could create an issue with having clear title going forward. So we don't generally recommend that. And thank you. Someone just sent over a resource, so I'll take a look at it. Thank you.
So Britt, I don't see any other questions in the chat, but I will give it another, 2 to 3 minutes just to see if anyone else has any questions. I also just want to remind the group that you can visit our website at burnerlaw.com. Under our seminars and webinar tabs, we have plenty of pre-recorded webinars that Britt and her colleague and mother Nancy have done throughout the year, so you can watch on different topics. Oh, here we go. I am the executor of my mother's will, and she refuses to do a trust. If she passes, probate takes a year. I must dip into my own finances to pay expenses. Britt, any advice on that? I know it's just a webinar with general information.
Yeah, so when you have to use your own assets to pay, obviously you can get that back off the top. But I think this person specifically saying, what if I incur a tax consequence or a liability because I have to take from a tax deferred retirement account to do so? And now, you can't put it back in. I believe you have 60 days after you take a distribution to put it back in. So obviously, if it's a year or so, that's not a great situation. And I don't think that the IRS is going to make an exception in this case. It's a hard spot.
Okay, Britt. So I think that ends the questions. Again, like I said, you can always visit our website at burnerlaw.com. We'll be hosting many of these in the upcoming new year as well. So please be sure if you want to join our email list, you're on our email list so you get notice of future webinars and future topics.
Great. Thank you, Michelle. I hope everybody has a nice day and happy holidays.